The transition from private record to public recognition. How to enforce without surrender. 1. The boundary between worlds. Private law governs the living. Public law governs the dead fiction. The challenge is crossing that line without getting buried under statutes. The executor's judgment must touch the public record, but never submit to it. So what does that actually mean? It means you knock on their door, not move into their house. A private judgment remains yours when entered as notice, not as pleading. You don't ask for permission, you inform. The difference is jurisdictional. One begs for remedy, the other declares it. Footnote. Public recognition occurs through notice of record, not submission of jurisdiction. Declaration replaces petition. 2. Translating the judgment, from equity to administration. Public officers can't act on private beliefs, they need paperwork. The executor's job is to translate equity into administrative language. That's done by attaching certified copies of your judgment with a letter of instruction explaining its lawful status. So what does that actually mean? It means you speak their dialect, but you keep your passport. When properly formatted, public clerks, auditors, and agencies can acknowledge your record as lawful notice. They don't have to approve it, they merely log it. Once logged, it stands as recognized evidence under public record-keeping statutes. Footnote. Translation through certified copy and instruction converts private record into publicly acknowledged evidence without ceding jurisdiction. 3. The lawful recipients, who gets the notice. Strategic recipients turn private law into recognized fact. The key offices include the U.S. Trustee, for federal financial oversight, the Inspector General, for misconduct or administrative review, the State Attorney General, for record notice, the County Recorder, for public evidence only, not filing. So what does that actually mean? It means you don't chase approval, you build an audience. By notifying these offices, you transform your judgment into public knowledge. Once it's visible, any future action against you must account for it, or risk fraud upon the record. Footnote. Notice to Oversight and Record Offices establishes constructive public knowledge, creating mandatory recognition without judicial submission. 4. Enforcement through acknowledgement. Once acknowledged, the record begins to move through administrative channels. Banks, agencies, or courts receiving your notice are bound by duty to respond or stand in dishonor. The executor's advantage lies not in confrontation, but in procedure. So what does that actually mean? It means you don't shout at the system, you let the system echo your paperwork. By maintaining certified proof of delivery and silence, enforcement becomes self-executing. Your record compels recognition not by force, but by compliance with their own rules. Footnote. Administrative enforcement arises from internal compliance obligations triggered by lawful receipt of certified notice. 5. Staying in honor, the executor's golden rule. Never gloat. Never threaten. Every document is an invitation to peace through evidence. Honor maintains jurisdiction, hostility forfeits it. Remember, equity protects the calm hand, not the clenched fist. So what does that actually mean? It means your best weapon is your pen, dipped in patience, not ink. Once public recognition is achieved, your record speaks for itself. The executor becomes an example of lawful remedy through precision, humility, and quiet persistence. Footnote. Jurisdiction is preserved through composure, honor maintains lawful standing where aggression invites forfeiture.